Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Hey, I appreciate all of that positive feedback I got on those last two shows regarding the violence in the workplace, etc. Some people wrote in and said they took very good notes. They're going to do a little bit more research, which is what I encourage them to do as well. Okay, well, this next one is one of those getting back into my what the hell are they doing in California mode. The California Supreme Court has addressed the issue of, let's just put it this way, suitable seating requirements for employers. Now, what's this all about? This is all about a person being at work and whether or not that the employer has to provide suitable seating for the person. Now, this interpretation that they're doing, and I just want to read some of this to you, is that there was an issue in two different cases, and I don't want to get into case names and all of that, but in those cases, it came up that there was a question on the California wage order provision. Now, the California wage order provision is what we call the IWC orders, etc. You need to have those posted if you don't have them posted. And depending on your industry will dictate which postal requirements there. But on the wage order, and it states that all, and look at 14A, by the way, on your wage order, states that all working employees shall be provided with suitable seats when the nature of the work reasonably permits the use of seats. Now, does the phrase nature of the work refer to the individual's task performed throughout the workday, or to the entire range of an employee's duties performed during a given day or shift? Now, that's what the California court is saying. Now, when determining whether the nature of the work reasonably permits, and that's in quotes by the court, use of a seat, what factors should courts consider? Specifically, are an employer's business judgment, the physical layout of the workplace, and the characteristics of a specific employee relevant factors. So those relevant factors, I'll go back through those again. Specifically, are an employer's business judgment, the physical layout of the workplace, and the characteristics of a specific employee's relevant factors. Are those relevant factors? And the third area that they were addressing, if an employer has not provided any seat, must a plaintiff prove a suitable seat is available in order to show that the employer has violated the seating provision. Now look, here's the problem with this. The problem with this, even if you look on the IWC order on 14A, what is the definition of suitable seating? Now, I can tell you that we've had an issue with this in the past, but not because it was on the IWC order, that a person wants to turn around and tell the employer, you know what, I've got a back condition, or I've got this, I've got that, and, you know, my doctor says that I need to change the seat that's at work. I had one situation where, I kid you not, the employer did everything they could. They had 4 or 5 different chairs that they purchased and bought in for this employee. And every time this woman sat in the chair, she always found some little thing wrong with the chair, to the point where the employer was getting so frustrated because they had gone over and over. They even got, you know, from the doctor, how high, you know, what are the characteristics, what is it she needs? They got so frustrated with this, all behind this employee, that no matter what they did, you know, with this chair, it was just not good enough. I think the employee actually used that as a basis for quitting, to be perfectly honest with you. And then she tried to raise some issue about accommodation, but that didn't go anywhere because the employer had all of the proof that they had purchased all of these chairs and that they had done everything reasonably possible, and it ended up disappearing. But this business about rooting, about this suitable seating, that's going to be subject to somebody's subjective opinion, in my opinion. But now, I will tell you that the California court, those 3 areas that I just gave you, the California Supreme Court answered the question as follows. The nature of the work, that's what number 1 that I gave you, the nature of the work refers to an employee's task performed at a given location for which a right to a suitable seat is claimed, rather than just a holistic consideration of the entire range of an employee's duties anywhere on the job site during a complete shift. If the task being performed at a given location reasonably permits seating, and provision of a seat would not interfere with performance or any other task that may require standing, a seat is called for. Now, I can tell you that I worked at a bank when I first came to California as a teller. This was years ago. Security Pacific Bank. They gave us seats. You're standing on your feet 8 hours a day. They gave us seats. I go into some banks right now. They don't have seats for their tellers, and they literally are standing there all day long, other than whatever breaks they take. So I'm not an advocate of that, I can tell you. Number 2, the court said, whether the nature of the work reasonably permits sitting is a question to be determined objectively based on the totality of the circumstances. An employer's business judgment and the physical layout of the workplace are relevant, but not the positive factors. The inquiry focuses on the nature of the work, not an individual's characteristics. So they're saying work versus the individual, not the employee's characteristics. Number 3, the nature of the work aside, if an employer argues there is no suitable seat available, the burden is on the employer to prove unavailability. Look, what's going to happen with that? You know that this person, an employee, is going to go to an attorney. They're going to say they're in violation of Section 14A. And here's where this is so much in the gray area, even though the court is trying to clarify these things. So what are they going to do here? The burden is going to be on the employer. Basically, that's it. They got to be able to prove that it's not a suitable seating situation. And what did we already talk about a few weeks ago? Who's sitting in the jury box? Employees. It's not managers. Managers generally aren't there. Why? They got too much work to do. Employees, well, we'll just say they look at it like it's vacation and they're away from work. Now, look, don't start sending me any hate mail talking about, there's civic-minded employees and aren't just sitting there looking. I get that. I understand that. It's not necessarily going to be everybody. But come on. There's employees who look at going on jury duty as an opportunity to be away from work, doing something that's kind of interesting, sitting in a jury box and, listening to all of the evidence. So I get that. But it's not every single one of them, they're sitting there just because they're civic-minded. They're sitting there because they got called to be there. So let's keep that in mind. All right, there's nobody down there volunteering for jury duty. All right, so now, the last issue that the court was asked to do was to decide whether or not, as part of his or her case, a plaintiff has to prove not only that the nature of the work reasonably permitted sitting, but also that a suitable seat existed, but was not provided. Okay, what does that mean? That means the employee can go do a hard target search, find these different chairs at either Office Depot or Office Max or some of these places that sell these things, Staples, and say, hey, I found these chairs right at Staples. I sat in these chairs and these chairs were great. And these chairs, in comparison to the chair that I have at work, are much better. So there you go. They're going to be able to turn around and say, now, the court held that this was not a part of the burden on the employee, though. All right. Section 14A, according to the court, unambiguously states that employees shall be provided with suitable seats. There is no language suggesting that an employee, additionally show a particular type of seat would fulfill that requirement. But what a plaintiff attorney is going to say, we'll see. An employer seeking to be excused from the requirement bears the burden of showing compliance is infeasible because no suitable seating exists. So the good news for an employer is that the employer really does get to determine about this suitable seating, that no suitable seating exists. But just remember, you're going to have to be able to prove that. Now, is what I would suggest to employers is that, okay, if we're talking about suitable seating, what are we talking about? The nature of the job. What kind of job that they have? If this is a person that has to stand all day long, then I would say that that's going to be a hard burden to meet, because why don't you provide some type of chair for them? Look at security guards. Security guards, a lot of them, they stand on their feet all day long. Well, with a security guard, in my opinion, are they roaming around? The answer is probably yes, because they're looking at the property, securing the property. I would say that's not a suitable seating situation. A teller at a bank who has to stand all day long? And like I said, the bank I bank at, not going to give the name, but they got their teller standing all day long. All right? Well, at least at one of the banks. Well, no, actually, yeah. The banks I bank at, the tellers are standing. Why that is, I have no idea. Now, look, here's the takeaway. The California Supreme Court decision provides some guidance regarding the parameters of California's seating requirements. So the court says the objective totality of the circumstances approach adopted by the court means that any time an employer determines that job duties require standing, a judge or a jury could second guess that decision and objectively view the circumstances. So what do I say? Use common sense, all right, with the suitable seating issue. And if you have somebody that's got some issue going on medically, then you really want to try to do something, because we don't want to add fuel to the fire. All right, with that last comment, it's time to close out this segment. But let me remind you that you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday, and we can be reached at 855-4J-POTS or 855-487-6887. All right, that's again 855-457-6887 between 9:45 and 11. Or you can email us at listenup@jameswilliampottsllc.com. Okay, I'm Jim Potts. I want to thank you for listening. I will continue to fight the fight.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.